Welcome to the Explainer. Look, if you've recently been appointed as an executor, an administrator, or a trustee here in California, well, you've just been handed a massive legal undertaking, right? Wearing that fiduciary hat is definitely an honor, but it also comes with incredibly strict rules and some really heavy statutory mandates. You aren't just managing money, you're stepping into a highly regulated arena where literally every move you make is going to be scrutinized. But don't worry, today we're going to break down the exact legal blueprint you need to follow so you can execute your duties flawlessly and, most importantly, keep yourself out of trouble.
All right, let's take a quick look at our roadmap for this explainer. 1. We'll cover the core fiduciary duties. 2. Initial logistical mandates. 3. Inventory and creditor claims. 4. Taxes and final accounting. 5. Shielding yourself from lawsuits. And finally, number 6, consulting DP legal solutions.
Okay, so let's dive right in by defining exactly what's at stake here. Under California law, a fiduciary duty is literally the highest standard of care that exists. It's not just a casual obligation, you know? And if you fail to meet this standard, whether that's by missing a deadline, mismanaging an asset, or maybe playing favorites, you expose yourself to what the court calls a surcharge. And trust me, you do not want a surcharge. It means you can be held personally, financially liable for any losses the estate suffers. Put simply, mistakes can quite literally come directly out of your own pocket.
Part 1. The core fiduciary duties. Let's look at the 4 pillars.
Okay, so every single action you take has to be tested against these 4 duties. First up, the duty of loyalty. This means you act solely in the best interests of the estate or trust, period. Second, the duty of impartiality. You absolutely must treat all heirs equally, even if there's, decades of messy family drama. Third, care and prudence. Just manage these assets like any cautious, prudent person would. And finally, the duty to segregate assets. Now this one is huge. You must never, ever mix estate funds with your personal funds. You'll actually need to set up a dedicated fiduciary bank account using a brand new employer identification number, or EIN, issued straight from the IRS.
Now, under that duty of loyalty, there's a concept called self-dealing, and it is heavily scrutinized in California. Basically, you cannot buy an estate asset for yourself, you can't rent estate property to yourself, and you definitely cannot sell your own property to the estate. Self-dealing is an absolute primary trigger for messy, incredibly expensive, and protracted litigation. It is literally the fastest way to get sued by a beneficiary. Moving on to Part 2, Initial Logistical Mandates. We're talking about the first 90 days.
So, shifting our focus from those core principles over to the immediate ticking clocks of the California statutory timeline. Basically, when someone passes away, the clock starts instantly. Phase 1 happens in the very first month. First things first, you've got to secure and insure the assets. Change the locks on any real estate immediately, lock up vehicles, and make sure all property is fully insured. Second, get that specialized fiduciary bank account open. And listen carefully to this part, never, ever pay estate debts out of your own pocket, and never deposit an estate check into your personal bank account. Finally, if you're administering a trust, you have a super strict 60-day deadline to mail a statutory notice of administration to all beneficiaries and heirs. Mark your calendars for that one.
All right, once those immediate tasks are handled, you hit the 90-day mark. Under California Probate Code Section 9202, you're strictly mandated to send formal legal notice to 4 specific state agencies. First, you've got to notify the Franchise Tax Board to check for back taxes. Second, the Department of Healthcare Services to see if the estate owes anything back to Medi-Cal. Third, you have to notify the Victim Compensation Board just in case an heir was ever incarcerated. And lastly, the Department of Child Support Services to check for any outstanding child support obligations. Seriously, do not skip these notices.
Part 3. Inventory and creditor claims. Identifying assets and debt.
Okay, so the absolutely crucial point here is the 4-month deadline. Under Probate Code Section 8800, you have exactly 4 months from the date the court actually issues your letters to file a complete inventory and appraisal. You'll do this using Form DE-60. And get this, California actually requires you to use a court-appointed official, they're known as a probate referee, to value any non-cash assets like real estate or jewelry. So you've really got to get this list of assets together extremely early so you don't blow past this deadline.
Right around that same time, you'll also be managing creditor claims. You have to give any known creditors formal notice, and they get 4 months from when your letters are issued to file a formal claim. Now, once a claim lands on your desk, you have just 30 days to either accept it or reject it.
If you reject it, well, the clock shifts back to the creditor. They then have a very strict 90-day window to file a lawsuit against the estate, otherwise their claim is permanently barred. It's essentially a rapid-fire legal volley.
But here's a vital protection for the estate. There is an absolute 1-year limit from the decedent's date of death for creditors to file claims. This is governed by California Code of Civil Procedure, Section 366.2. And I mean it, this is a hard stop. It actually doesn't even matter if a probate was officially opened or not. Once 1 year from the date of death has passed, all unknown creditor claims are strictly barred. End of story.
Part 4. Taxes and Final Accounting. We're looking at months 6 to 12 and beyond. Now, you probably know you have to file the decedent's final individual state and federal tax returns. But what a lot of people miss is the California Fiduciary Income Tax Return. That's Form 541. You are actually required to file this if the estate generates gross income exceeding just $8,000 or net income exceeding $1,000. So if you've got rent checks coming in, dividends, maybe some business income, yeah, all of that counts. You've got to be watching these thresholds super closely.
And right alongside those taxes is the final accounting. Listen, before you can close probate or distribute any assets to those impatient beneficiaries, you must present a meticulously detailed final accounting. I'm talking about tracking every single penny that entered the estate and every single penny that left it. You have to prove exactly where the money went. If your records are sloppy, the judge will absolutely reject your accounting, and you could be facing that dreaded surcharge we talked about earlier.
All right, Part 5. Shielding yourself from lawsuits. Let's talk about risk mitigation.
So, because beneficiary litigation in California almost always pops up from a lack of transparency or just failing to follow procedural rules, let's look at a really common mistake. And that's acting on a handshake or a verbal agreement with family members rather than using the proper legal tool, Form DE-165, the Notice of Proposed Action. Here's the deal. If you're going to take a major action, say selling the family house, you serve this notice on the beneficiaries. It gives them exactly 15 days to object. If they don't object in writing, they generally lose the right to ever sue you over that decision later on. It is by far your best, most powerful shield. Please do not rely on text messages or handshakes. Use the statutory notice.
Building on that, here are 3 more ways to completely insulate yourself. First, keep meticulous written records. I'm talking about documenting every phone call and saving every single receipt because remember, the burden of proof is on you if an expense gets challenged. Second, never, and I mean never, hand over a final check without getting a signed receipt, release, and indemnification agreement. That piece of paper legally binds the beneficiary and releases you from future liability. And third, use estate funds to pay professional advisors. The Probate Code explicitly allows you to hire attorneys and CPAs using the estate's money, not your money, to make sure the administration is handled correctly. Use that to your advantage.
Part 6. Consult DP Legal Solutions.
So, as we've seen, the burden of proof is sitting heavily right on your shoulders, but you really do not have to carry it without professional legal backing. I want to leave you with this provocative thought. When you accept the role of a fiduciary, you're literally putting your own financial well-being on the line. Are you ready to risk your personal assets by just guessing your way through the California Probate Code? Or are you ready to actually protect yourself by doing it exactly by the book? Because these rules are so complex, relying on professional legal advice is quite literally your strongest defense against claims of mismanagement. Please don't try to navigate these statutory timelines and mandated forms alone. Reach out and contact attorney Peter Fung Long at DB Legal Solutions to secure your legal shield today. They're going to ensure you execute your duties flawlessly, protect your personal assets, and ultimately honor the legacy of the estate. Thank you so much for joining me on this explainer, and hey, stay focused out there.